Hi, I am Debbie Reekie. I am one of the Senior Associates at BTO in the Family Law team, and I am here today to answer one of your questions of the day, which is if you are in a lockdown situation, can you still get protective orders from the court? And the quick answer to that is absolutely you can. One of the major concerns that came out of the lockdown restrictions being put in place was the potential for domestic abuse incidents to increase, and for someone who is the victim of domestic abuse to be unable to leave and find a place of safety. It is important to note at this stage that one of the main exceptions to the stay-at-home lockdown message is if there is domestic abuse. If you don't feel safe staying within the family home, then don't. If you are in immediate danger, then call 999. If you're unable to speak, press 55. That will alert the call handler. Alternatively, contact us in whatever way you feel able to, and we can give legal advice and signpost you to any other organisations who may be able to provide further support. Domestic abuse covers a wide range of behaviour, and the Domestic Abuse Scotland Act defines it as a course of conduct which is abusive towards a partner or ex-partner. A reasonable person must consider that the conduct is likely to cause physical or psychological harm. Examples of domestic abuse include physical abuse, psychological abuse, financial control, coercive control, domestic abuse and online abuse. Being the victim of domestic abuse can be frightening. However, there are many civil remedies that can be obtained from the courts if necessary. The courts are still only really dealing with very urgent things, although every day they are making some progress. However, there's no doubt that if you need the protection of a court order, then your own safety will fall within the scope of urgent cases currently being dealt with by the court. So what kind of orders can you obtain from the court? The first kind of order you could look to obtain is an order called an exclusion order. An exclusion order is an order excluding someone from their own home. To obtain an exclusion order, you have to show that the behaviour is injurious to your mental or physical health, or to the mental or physical health of any children who live in the property. An exclusion order is usually used for someone who is married or in a civil partnership. However, it can also be used for a cohabiting couple where they are joint owners or joint tenants and both have what's called occupancy rights to a property. It's important to note that you don't have to be living in the property to obtain an exclusion order, and you can still obtain an exclusion order if you've moved out. However, your right to apply for an exclusion order will lapse after 2 years. Breach of an exclusion order is punishable by the courts. In the meantime, it's important to remember that you can't exclude someone from their own property, for example, by changing the locks without a court order. Alternatively, the court could look at granting an interdict, which is an order preventing someone from doing a particular thing. For example, approaching you, contacting you, or coming within a certain distance of your home or your children's school. The court can grant an interim interdict when the case first calls in court and before the defender has an opportunity to appear. However, the interdict is not effective until it's served, which is usually done by sheriff officers on the defender personally. It is possible to ask the court to make a determination that an interdict is what's known as a domestic abuse interdict, and also to attach a power of arrest to the interdict. What that means is if the person breaches the interdict, the police will automatically arrest them as they will be guilty of a criminal offence. Alternatively, the courts could consider a non-harassment order. A non-harassment order is designed to protect someone from a course of conduct which amounts to harassment and causes the person fear, alarm and distress. This would usually cover things like text messages, social media posts, unwanted letters, emails or even visits. Again, a breach of a non-harassment order is a criminal offence. So in summary, there are many different options open to you if you are the victim of threatening or abusive behaviour from your spouse or partner. Which option is best for you very much depends on your individual circumstances, what kind of protection you need, and what kind of conduct or behaviour you need protection from. If you are concerned about someone else's behaviour towards you and feel the need to take steps to protect yourself, then please do get in touch. We can discuss your circumstances, your needs, and agree on the best option for you.